We want to hear them talk about their relationship with both parents. But how do we do that? In court, we don't actually hear from the parents, and in a mediation, you're not hearing from in court, we don't hear from the children. And in a mediation, you're not hearing from children either because you've got the parents in front of you. Ask them about their relationships. Ask them to describe the child to you. The statute asks us specifically to think about the strength, nature, and stability of the relationship with each parent. So when you're in a mediation, if you are actually having that conversation with them, it'll help pull out the information about who's doing what and who actually knows the child or children. I think about it in terms of my own child, right? My kid had a division of labor with the parents. He never asked me for help with his math homework, particularly not when it got to high school and it was calculus. Very smart of him. That was not my forte. But when he wanted to skill and drill in basketball, that was all mom, because dad didn't play basketball. Mom did. And if he wanted the parent that was, he figured it out, right? So we had different things that we did with him. And if anyone talked to us about our experience with our child, it's going to be really different because each one of us knew him in a different way. So draw that information out. Dad's the one that tells jokes and debriefs the day. Mom reads bedtime stories every night. Even when I was in trial, I would come home, put my kid to bed, and then go back to work rather than miss out on that routine. Find out those unique things that people are doing with their children so that the parenting plan can keep those things in place. And remember that we have a tendency to think about our own experience, like I just did, mom, dad. But some situations are going to be two moms, two dads, where in a world where there are thruples, there's lots of different ways. There can be more than one dad, there can be more than one mom, there can be three parents. It's getting to be lots of different things are normal. And so be aware of the nuances of all of those things. Remember that there are adoptive children, and legally an adopted child is the same as biological child. So don't have differences. We won't have differences in the way that we treat children. So don't allow there to be two separate ways of analyzing relationship with children. Set aside your assumptions. I have to every day about who's nurturing. It's not always mom that's the nurturing one, and it's not always dad that's the disciplinarian. It could be the other way around. Listen without assumptions based on your own experience. It's something that we as judicial officers have to do every day. So it's helpful for you to know what we're thinking about, because that'll guide how you're helping people through the whole mediation process and coming up with a parenting plan that makes sense for them and their children. Questions about this factor and how we think about it? Okay, yes. So I can tell you from how I handle it in court. I'm really limited in how I can do that, but I think there are other mediators that can tell you how, experienced mediators in the room that can tell you how they handle it in a mediation. In court, I have, unless it's an informal trial, I have limitations on how I can interact with people. I can't direct the testimony, right, unless it's an informal trial. So when I find, whoops, that people are focusing most of their time and energy on proving that the other person is a bad person, which happens a lot. And I'm sure that those of you that have mediated have that experience. I interrupt and I say, what I really need to hear is, what's your relationship with your child? How, what did you do with your kid when you were together? How did that interaction go? What is your child like? What are the activities that you do together? Like really general, broad things so that they're telling you. Open-ended questions that allow them to give you the information as opposed to suggesting the information, if that makes sense. So super open-ended. I stick with the language of the factors. Tell me about your relationship with your child. That doesn't work because sometimes it doesn't. I say, tell me about your kid. What are they like? Or I'll say, tell me a little bit about Andrew, Sarah, Sally. I'll use their names and try to just keep it focused on the child as opposed to the conflict. Because let's face it, they're here with you or me because of conflict. So the next factor is performance of parenting functions, past, present, and future. The statute actually defines what parenting functions are and prioritizes them in a way that we're supposed to think about. So I'm going to go through those different functions. This legislature has decided that maintaining a loving, stable, consistent, and nurturing relationship with a child is a parenting function. Pretty straightforward, right? And not hard to get people to talk about. What do you love about your child? What do you, how do you handle this situation or that situation? And you're mostly doing mediation with everybody in the same room, right? It's the collaborative model. So you'll hear different things and maybe they'll chime in on the different. I try to think about it in terms of, if my husband and I were describing our son, we would both have completely different definitions of who he is, because our experiences with him are slightly different, right? So we describe him, same kid, but we describe him differently. And you'll hear the love in the way that we describe our child, right? I know he's grown, he's married, he's still my baby, right? So you hear that when we talk about our children. And you'll hear it when the clients are talking about their children. That care comes through. So who is doing the nurturing? Attending to the daily needs of the child, such as feeding, clothing, physical care, and grooming, supervision. Children need supervision. Even teenagers need supervision, but everything looks different. How do you draw out that information about who's doing that type of parenting function? And you don't have to go through it with the fine-tuned comb the way that we do. You only have so much time. Just broad general questions, keeping in mind that the judicial officer is going to be thinking about this in more detail if they don't come up with an agreement in front of you. Attending to the adequate education for the child, including remedial education, if that is necessary and critical to the best interest of the child. Assisting the child in developing and maintaining appropriate interpersonal relationships. Are they supporting relationships with other people, or are they isolating the child and just having interactions with the child themselves? Are there other family members that they're exposing the child to, other children? Are they setting up play dates? Children need all of those things. Children need to be social, and just having a one-on-one with a parent isn't enough to develop a fully formed human being, right? So who's supporting those things? Exercising appropriate judgment regarding the child's welfare, consistent with the child's developmental level and the family's social and economic circumstances. I think the legislature put this language in there so that we don't hold it against people if they don't take their kids to Disneyland. We need to think about where they are and meet them where they are. And children don't need to go to Disneyland. They do need to be able to run and play and have healthy relationships with their parents. So, what does that look like? It's going to be different for everyone. And believe it or not, the last factor in parenting functions is providing financial support. So it is one of the things that the court is thinking about. Are you financially supporting your child, whether you're there or not? I have been doing this work for a really long time, as you heard. So to me, these factors just seem logical and the types of things that you would normally be thinking about when you're thinking about who's parenting. Do people have questions about this? And is any of this a surprise? Yes. That's at least on purpose. That's it doesn't, because it's one factor out of all of these different factors, and it's only one piece of parenting functions, right? So sometimes people say that because we have to consider financial ability, that that means that that's the parent that gets the child, but that minimizes all the other factors I just talked about, right? So they're not these are not weighted, and when they're weighted, it's the person that provides the day-to-day care factor that is weighted. So the financial support is important, but it's not weighted. And if you look at the way that child support is calculated, it's proportionate to their incomes. So you have a worksheet, you don't mediate child support, right? They come into court, they tell us how much they make, we plug it into a worksheet that has assumptions about how much time parents are spending with their children, and it spits out a number that's proportionate to their income. So it's important that they're financially supporting the child, but it's not that only the parent that can afford to financially support the child that gets custody. It may be that the parent who provided the day-to-day care made sacrifices in their career in order to provide the day-to-day care, or because daycare was too expensive. And so the other parent is providing the financial support while this parent is continuing. The idea is to keep things as similar for the child as it was when they were together and maintain those relationships. So just because one parent, and I hear this a lot, I can afford to give them a better life. That is not what the statute requires. You can and you should continue to financially provide that support so that they have that level, that standard of living while living with the other parent who provided the day-to-day care and that we know is going to maintain their emotional well-being if they have that contact. I told my husband a long time ago, we can't get divorced because then you would get primary custody because I was busy litigating and he was parenting. So he was the primary parent, and there was nothing wrong with that. But I wouldn't have been able to do the bedtime stories every night because that's not something we could have maintained, right? It was a joke. We're still together 29 years this year. 29 years this year, and we're still going strong, and the kid's 28. And we still have a good relationship with him and his wife. And really, that's the bottom line, is how do we create parenting plans that maintain those relationships between children and their parents so that they can have those relationships into adulthood. I tell people, do you want to be at graduation? Then you got to figure out the conflict so that you can both be invited to graduation. You want to attend your child's wedding. If you don't sort this out, you won't get a chance to attend your child's wedding because they don't want this conflict and they won't invite either one of you. So parenting plans should think into the future and how do we have that relationship in such a way that it considers the past. What did they did in the past? What are they doing in the present? And what's the potential for the future? And the statute literally talks to us about that. What did they do in the past? It's not uncommon that the parent that was working a lot suddenly starts working less hours so that they can maximize their quality time with a child after a separation, because they suddenly realize I'm not going to have a relationship with this child if I don't work less. That's not uncommon. So think about it from past, present, and future, or I should say, encourage your clients to be thinking about it in that way. Because you're not really telling them what to do. I am at the end of it. If you can't decide, I'm going to tell you. And I'm going to tell you what I think is best for your kids based on the information you present to me. So presenting that information is key. When I do settlement conferences, I hear people know what they did and they know what's right, but they don't often hear each other because of the conflict. So when you talk about these things and you frame it in terms of the children, it's easier for them to hear it as opposed to staying stuck in the conflict, if that makes sense. All right, questions about parenting functions?
That is
They are all in the statute. I'm literally reading the factors out of the statute. Are you talking about a settlement conference with a judicial officer? Yes, absolutely. So the question was how much time well, the first question was, is all of this in the statute? And my answer, as you heard, was yes, I am actually reading from the statute. And the second question was how much time is involved? Hopefully none, because we send them to you first, right? They come to a temporary orders calendar. We enter temporary orders to stabilize things based on the information we have, and we send them to mediation. They sit down with you in mediation. If you're successful, they come back with a final order. We enter the orders, and they're done with court. And that's really healthy for people to be done quickly, because court by its very nature is adversarial. If they're not successful in mediation, or if there's some reason that we waived mediation, then the next step is a settlement conference. Right now, we schedule 1-hour settlement conferences. So they sit down with us for 1 hour. Sometimes that's enough time to get through the issues. Sometimes it's not. The first question that I ask in every settlement conference is, I have 1 hour with you. We can narrow the issues, or we can work on something that you think we can accomplish in an hour. You tell me what are we going to be most successful with in this hour? And I find that if we are successful in the conversation with me in a settlement conference, or with one of our commissioners or pro tems, that they are more likely to be able to resolve everything short of a trial, because they see how the conversation goes. You're modeling how to have a respectful disagreement, right? That's the key. I often say when people ask my advice about a successful marriage, to disagree successfully, disagree without rudeness or anger. You have to argue. If you don't argue, then you don't care anymore, right? But how do you argue respectfully? That's the key. And they are demonstrated that when they go to mediation or they're sitting in a settlement conference. So that's parenting functions and settlement conference. Let's talk about the next factor that the court has to consider in terms of a parenting plan. And yes, there are a lot of them, and we consider them all, and we just walk through each one. Emotional needs and the developmental level of children. That's what the statute says. I have the privilege of working here in Thurston County, where we get a lot of training on child development. And I had an interest in children even before law school. So I took child development classes. So from my perspective, based on my training, what do children need? They need to give and receive attention that's focused on them and about them. They need to respect the mind and body connection, and to have parents that are helping them develop that. Children have a need for purpose and goals, don't we all? Children have a need to have a connection to something that is bigger than them. They need stimulation and creativity. They need to feel understood and connected. And they need to feel a sense of control. So I am looking and listening when parents are testifying at trial for who is actually understanding and meeting a child's needs. So if they're not successful with you and they're not successful with one of our commissioners at a settlement conference and they make it to trial, I'm listening for who really is setting up their child to be a successful adult. Questions about emotional needs and developmental level. One of the things that we've learned is that children view themselves subconsciously, so they don't realize they're doing this, as part one parent and part the other. So when they hear negative things about the other parent, they tend to internalize that as a criticism of themselves. So we see a lot of acting out behaviors from children who are involved in high conflict divorces because they're hearing criticism about the other parent, which is impacting them as criticism about themselves. That was something that really astonished me, but research shows that it is something that children subconsciously do. So it's not something we can talk them out of. So what we can do is encourage parents to not speak negatively about the other parent in the child's presence or allow anyone else to do it in their hearing. And many, many, many of the parenting plans that I have signed actually include that as a condition. Do not disparage the other parent in the child's presence or allow anyone else to speak negatively about the parent in the child's presence. Once I learned that that was a negative impact on the child, it just became a standard for me. And I share it in every ruling. Relationships. Children need relationships with more than just their parents. Hopefully this is not a surprise. And the statute actually requires us to consider who is fostering relationships with other family members, siblings, step parents, extended family, who takes them to family get-togethers and who isolates them. We are looking at those things. And it's not good parenting to only spend time with your child, you alone, if that's all you ever do. It's great parenting to have that one-on-one time with your child, as long as you're also fostering relationships with other people and building those supports and structures around your child. So balance always. Questions about that? Siblings, grandparents, it's all important. Not a surprise to anyone. Maybe the only surprise is that the legislature thought about it, but they're people too, right? And they know, we assume that they know what they're doing when they write the law, right? They spend time on putting all these factors together. And these factors have been in the statute for a long time. So the next factor that we think about is physical surroundings. So we try to minimize disruption. We try to keep them in the same school and activities to the extent that we can. So how do we do that? If one parent is moving out of district, we know that a change in schooling impacts their education. Every time there's a change from one school to another, there's a setback. So we do our best to see who's going to maintain the connections. Sometimes it cannot be helped. and sometimes it can. So again, one factor out of a long list, we consider them all, and they're not weighted. Questions about that? Okay. How many of you have heard that a child gets to pick when they're 13? So one person, our lawyer, has heard that. Have the rest of you not heard that at all? No one's ever said, how old does my child have to be? You felt it. You felt it as a child. Tell me more. Really? So were your parents split? And they gave you that choice? So you did. You asked for it.
No, they told me.
They told you. Okay. So her parents actually told her at 13 that she had a choice.
They said like how you're older.
Okay. So who knows what age you have to be to choose who you're going to live with? The lawyer in the room said 18. Does anybody disagree? Any other guesses, online or in person? I mean, we've got lived experience of 13 right here, right?
I wasn't choosing who I was gonna live with.
Ah, you were not choosing who you were going to live with. What were you choosing? Okay. So they adjusted the schedule according to your wishes. Okay. And that is correct. The law does not allow a child to choose until they are correct. It is a myth that they can choose at 12 or 13. In fact, you do not have executive function until you're 25. So arguably, we shouldn't allow people to decide who they're going to live with until they're 25. But legally, you're an adult at 18 and you make lots of decisions between 18 and 25, for better or for worse. Biology is not perfect, right? So people develop at different rates, but the average male has full executive function at 25 and the average female at 22. Don't ask me why. But most of us are not average. And so we're all different. And the law says we get to decide at 18. I don't know where this myth comes from, but it comes up often. What the statute says is the court considers this as one factor. And this one factor has three parts: what the parents want and what the child wants. So, what does each parent want? What does the child want? And those three things are weighted as one thing in the whole long list. What does everyone want? We think about it, we want to hear it. And the statute specifically says, with respect to a child, if they are of a sufficient maturity to express an opinion. So when a case comes to you for mediation and you're successful, this issue never comes up. When a case comes to you for mediation and it comes back to us in court, it either gets set for settlement conference or we appoint a guardian ad litem. Guardian ad litem will interview the child. And when that interview happens, if the child expresses an interest in an open-ended way, most of our guardian ad litems will not ask, but if the child expresses an interest, they will report that to the court and we will consider it. So it is not the biggest factor. It is not the deciding factor. It is 1/3 of one factor. That's one of my favorite things to do, is to get out there and bust that myth. And I feel like over the years, as I've come to talk to mediators, that this myth is disappearing. that kids get to choose when they're 13. I think we just know more and more about adolescent brain development, and kids really need more supports between 13 and 17, not less. They just need different supports, right? That support their individuality and their ability to um, separate and become adults and become independent. They don't need babysitters. They need different kind of parenting, but it's still supportive and it's still parenting. And we don't decide you're grown when you're 13. Some cultures do.
For maybe
That's fair. So that I'm going to paraphrase because that was a long question. I don't think I can get it exactly right. But the question was, I hear in mediation sessions, a parent says the child wants to live with me, and the other parent says, no, the child says they want to live with me. And that he's hearing that as a negative. And he's pleased to hear that guardian ad litems don't ask directly, but instead ask general questions that elicit preferences and what they're accustomed to in a developmentally appropriate way. A 2-year-old can tell you preferences. What we know is that children will say what they think you want to hear when they're really, really connected to you. So it's not necessarily a negative thing if in a mediation, each parent says, but my kid says they want to live with me. That may very well be true. That child is connected to both parents and it's telling both parents, I want to live with you. But we don't want to put children in the position of having to choose between those parents, right? The idea is, to the extent possible, to maintain the relationships as they were when they were together, taking into consideration the geographical differences, the school schedules, but trying to maintain those connections that they had. So, as one of my colleagues likes to say, children don't count the hours. They look to the quality of the time that they have with parents. So we look to how do we maintain the quality of the relationship they have with each parent. Cases that are coming to you, unless we did something wrong or missed something, should not be the high conflict cases, or we don't know yet that they're going to be high conflict cases. The cases that are coming to you should be cases where there's a potential for mediation. So you may actually be hearing people say genuinely what they're hearing their kids say. And that's because kids want to please their parents. Kids love their parents, and they generally, if you ask them, don't want them to split up to begin with. They want everybody in the same house, right? Parent Trap is based on real life experience, entertaining, and apparently really popular because we have 3 different versions over the years, right?
normally we take cases involved. We would see that, but investigate. Believe that that's how we work. And rescue from I remember from the first one.
So I will check in with our commissioners about what they're doing now and encourage them to do it the other way around. But what we were doing when I was a commissioner is mediation first. When they come back from mediation for the mediation review, if they were not successful, then the guardian ad litem. A GAL is expensive, it's intrusive, it's one more person that's interviewing a child, and if it's not necessary, we don't add that. So you shouldn't be seeing cases after investigation. You should be seeing cases before investigation. And there are exceptions. But after an investigation, we realize that some of the things that were raised as huge concerns actually aren't, and they're appropriate for mediation. And so we'll order mediation, but that shouldn't be the rule. The rule should be that you're seeing cases before the guardian ad litem is investigated. But now, newly minted chief family and juvenile court is going to go back and check and see how we're doing things and encourage the least intrusive and most respectful to children approach. I don't know how the myth that children get to choose who they live with at 13 arose. It's something that I was appointed as a commissioner in 2007, and I heard it over and over and over in the courtroom. And I'm pleased to say in 2024, I'm hearing it less and less and less. I think people just assume once your kid becomes a teenager that they have more autonomy and the lived experience here, that they're mature enough to actually make better decisions. And maybe they are, but that's not what the law says. And we know that forcing children to choose between parents actually is damaging. There you go. I finally got there. Was there a question online? There's 3 questions online. Okay.
So the first one is, in the court system, does the court take into account the child's opinion more as they get?
Nope. If they express an opinion or a preference, we take it into consideration. There's no waiting for their age. The only language in the statute is if they are of appropriate maturity to state a preference. So it depends on the circumstances.
And the second question we have is, clients often ask that it has influence.
So, I can speak to that. 17 years, 17 years of doing this. I have had people come in and enter a 50-50 parenting plan or ask me to sign off on a 50-50 parenting plan where one parent was in another state. So they were going to do 6 months on, 6 months off, or a year on, a year off. How can I find that that's in the best interest of the child? I can't, because we know every time they change schools, there's a disruption. There's a negative impact on their educational well-being. I cannot agree that a year in Hawaii and a year in Washington is a good parenting plan. Because I have to make findings that this parenting plan is in the child's best interest. So I have to think about what's developmentally appropriate for the child. I've had people request 50-50 parenting plans for financial reasons because there's going to be a residential credit. And when I was doing the final orders calendar, there would be only one person has to come in. And then so I'm questioning that one person. And I literally had people say to me, don't worry, this isn't real. It's just on paper so that we can zero out the child support. Number one, a 50-50 parenting plan does not mean that the child support is zeroed out because it's proportionate to your incomes. It may mean a residential credit, but it doesn't necessarily mean zero transfer payment because child support is to maintain the standard of living of the child, which means that, yes, you are bolstering the standard of living of the other parent to make sure that the child has a home to go to in both places, in some cases. But a 50-50 parenting plan does not automatically mean a zero child support transfer payment. They're 2 separate issues. They're equally important. But if you're telling me that you're just on paper having a 50-50 parenting plan, then I can't find that that's in the child's best interest, because it's not reality. Your reality and your paperwork should match. Some states across the United States have a presumption in favor of 50-50 parenting. Washington used to have a presumption against 50-50 parenting. Since 2007, when the dissolution bill was passed, it has been that there is no presumption against, but there is no presumption in favor. And the focus is, what are the children accustomed to? So we are not looking at an automatic 50-50 and then moving from there. We're looking at the relationship of the children with each parent. And I'll use myself as an example again. I was a litigator, so I worked 6 days a week. I would be the alternating weekend parent and maybe a dinner visit if I had gotten divorced when my child was still a minor, because that's what my kid was used to, is quality time with me in lumps when I was available. And the effort that I made, right? And we would try to mirror that. We don't split days. Some states split days. I think that's really hard on children to have a split day. And we don't automatically do 50-50. If the parents were equally involved, and I think that I could make an argument that I was, because I'd sacrificed sleep to be home and get dinner with my child and put him to bed every day. My husband always did the morning routine. Maybe I could make an argument. We would never have had a split day. I would have had to change my work schedule to figure out how to make it work. But it has to be supported by the facts before we do a 50-50 parenting plan. Yes. They within their arrest. Why did they want that child their agreement? Yep. So their mediation agreement and go to the courts or Thank you. That's a great question. The question was in a collaborative model, when you are capturing their agreement and writing it down, whether you agree or disagree, how does it get turned into a parenting plan? And does the court assess whether it's in the child's best interest? And the answer is sometimes when people come back from mediation, they have that mediation report that just details their agreement and they file it with the court. Sometimes they don't, and they tell us that they had an agreement. We really appreciate the reports that we get from the Dispute Resolution Center that tells us that, yes, they did have an agreement, no, they didn't, because then we know if they're telling us the truth when they come in and don't have that written agreement. Sometimes they've met with the facilitator and drawn up a final parenting plan that's consistent with the agreement they reached with you. And sometimes we just sign off, because at the end of the day, an agreement that parents came to, they know their children. Every child is different. So we make decisions based on averages, based on factors, but not necessarily based on individuals. If they come back to me with a 50-50 parenting plan from you where one parent's going to be in another state, I am going to make some findings that that's not in their best interest. And they may or may not do that anyway without the court order, or they might end up going to trial and one parent may be really relieved that I didn't take their agreement. But a lot of times, if they reach an agreement with you, even if we have a little concern about it, we sign off on the agreement, as long as we can find it's in the best interest of the child based on the information they provide us, which isn't always robust.
one more question. How difficult is it for parents to get into that GAL?
So the question was, how difficult is it for the parent to get a GAL to sort out major decision-making and visitation and residential issues? It's impossible. A GAL is appointed to investigate conflict, investigate specific things such as whether there's domestic violence, whether there's substance use, whether there are things that are impacting parenting. So they don't make recommendations about schedules. They used to. That is not best practice. And so we have asked that GALs don't make recommendations. It is an inappropriate delegation of judicial authority to give that ability to a guardian ad litem. And what was happening is that GALs would make recommendations and parties would adopt that as their parenting plan without actually even running it by the court, sometimes feeling pressure because the GAL sided with one or the other. And there are many, many times where a judicial officer will look at a report and the factual information in the report and have a different conclusion as to what the residential schedule should be than what was recommended. So GALs are not evaluators that are there to show you the way to a final parenting plan. An attorney can give you legal advice and sit down with you and give you ideas and negotiate with the other attorney or with a self-represented party and help people come up with parenting plans that are in line with the law and the facts of your case. A GAL should not be doing that and is not doing that here in Thurston County. They are writing reports that are making recommendations. They are writing reports that are drawing conclusions regarding whether there's limitations, whether there's substance use, whether there's domestic violence, something that is impacting the ability of one parent or the other to parent. So a GAL is not to assist you in finalizing your parenting plan. Completely different thing. Hopefully that made sense. Things have changed a lot over the last 17 years. When I started, GAL reports would be 45, 50 pages with huge lists of recommendations for what should go into a parenting plan. And now they tend to be 10 to 12 pages, and they're just a summary of what the court asked to be investigated and interactions with the child. And they're really, really helpful in terms of the information. It's like Dragnet, just the facts. All we need is just the facts. I get to use that one because they redid it in the 80s, right? So it's not that old. So back to the statute. Work schedules. The statute actually asks us to consider work schedules, and so often people don't tell us what their work schedules are. And when people don't tell us, then we make bad parenting plans. So think about what their work schedule is. People do not always work Monday to Friday, 8 to 5. So an alternating weekend schedule for someone who works every weekend is not a good schedule. So we see a lot of really different parenting plans. Firefighters have really unique schedules. So they have really unique parenting plans. And that is okay. It does not have to be cookie cutter. It should be individualized to the people that are in front of you, and it should consider whether they get to spend time with their children on their time. It should be their parenting time. No parent should be reduced to a visitor. I don't even like to say visitation. It's parenting time. So that's what we think about. I think it's helpful for you to know what we're thinking about. And we've already touched on this a little, but next steps. If they can't reach an agreement in mediation, send them back to court to argue the orders. A lot of times I find that people don't know how to finish their case, but they have an agreement and they just didn't come back to court. So that's why we schedule the mediation reviews, is because we found so many cases where people just didn't know how to move their case forward. They didn't know what to do next. So send them back to court. If they reach an agreement in mediation, send them back to court so that they can reduce that agreement to writing and have an order. If they don't reach an agreement, we may appoint a GAL to do a custody evaluation. And I've already addressed this in terms of questions that came up, but they will investigate. They'll contact teachers, doctors, daycare, parents, kids, neighbors, get the information that we are not necessarily getting. And a GAL represents the best interests of children, not the stated interests of a child. We do have court facilitators here in Thurston County, and they are worth every dime. They are very inexpensive option for walking people through the forms. And they can't tell them how to fill out the forms, but they can point to the right forms and they can say, hey, this is blank. So that's really helpful. GALs have specialized training and mediators don't have that same training. So don't worry about it. If you didn't get to the right answer, there are other steps. Thank you for every time you're able to, through your collaborative model, reduce our caseload. It's like this big funnel, right? There's so many cases and we just want to winnow it down. And they are really two different things. We've already talked about my practice of sending people to mediation first, because then you don't have that intrusiveness of a GAL interviewing the child, and every new person is another stranger that your child is meeting in a really, really difficult time in their life. Anytime a divorce is happening, children are having a tough time. Okay. Yes. I feel like that's something that's up for what are your thoughts? So I know that you have rules about all of that, and I don't want to step on the toes of the DRC, but I will just say again that the statute says it's against public policy to mediate or negotiate child support. It's the child's right. It's not between the parents. Child has the right to the same standard of living, even though you're splitting up. There's a formula. It's a question of figuring out what your incomes are, putting it into a worksheet. And every one of the 50 states has the same statute. The Uniform Support Act has been adopted by every one of the 50 states. So you can tell them that it's determined against public policy. Your kid has the right to support from both parents, and then follow whatever rules that the DRC has about those things. But it's not an issue to be mediated. It's simply about figuring out what the incomes are. Yes. Yes.
Every year.
So You cannot engage in the unauthorized practice of law. So a lawyer could, I suppose, depending on the status of your license and your malpractice, assist in filling out the form because that is legal advice. But mediators should be submitting the settlement agreement and sending them to court facilitators who have the cover of specific rules that allow them to assist in pointing out the right forms. Mediators don't have that cover. So do I love it when I have people come in with parenting plan that's all filled out and I don't have to sort through all of that? Absolutely. But am I permitted to allow the unauthorized practice? No. So we follow the rules. I don't think it's the same thing because there are specific guidelines around mediators, but I don't represent the DRC or the mediator, so I will have you talk to the administration about how capturing the mediation agreement is covered, and keep my foot out of things that I'm not. Because putting your foot in it is not a good thing. But we can't authorize the unauthorized practice of law. But in the 90s, early 90s, when I was in law school, I was mediator and I got to capture the mediation agreement. So there are rules in place that allow agreements to be captured without crossing a line. And I haven't looked at them recently, but I'm sure that the DRC has. You're welcome. And hopefully there was enough of that conversation that it's all captured online, but there were questions about if it's the unauthorized practice of law to complete a parenting plan for clients, then how is it not the unauthorized practice of law to complete a contract? And hopefully there was enough in that conversation for you to get the gist of what I was talking about. Is there a question online? I see a hand.
That was, yeah, we already answered that, but there was one that
Okay.
so we're going all different modes here. Does the court pay for
The court does pay for GALs. We have contracts with GALs. So if people are indigent, we will appoint a county pay guardian ad litem to support individuals with that investigation. So if people cannot afford a GAL, we have a limited number of GALs that have a contract with the county that will do that work. They do not go to homes. They will do most of their investigation by phone, video call, or Zoom. So there's a slightly different feel to it than a private pay guardian ad litem, but they are a limited resource and they are a great resource so that they do a slightly different investigation at county expense because we have to be good stewards of tax dollars, but we also want information about our families. And so for our indigent families, we don't want them to be completely priced out of having that support. If we run out of the limited number of contracted GALs, every single GAL on the list has agreed to do at least one a year pro bono case. So we actually have a pretty good number of spots for our indigent families. Okay, so some general things that I want to touch on that are not necessarily going to come up a lot, but it's worth just sharing. Relocation, the most heartbreaking type of case. A moving parent files and serves notice of relocation and a proposed parenting plan. The other parent may file an objection to the relocation if they object to the move, or they don't object to the move, but they object to the proposed parenting plan. There's not always time for mediation. They're priority cases because it's usually a move that's job related. It's often someone or their spouse is moving because of the military, so there's very, very little time. And it's really heartbreaking. It's difficult. And there is a presumption in favor of the custodial parent. So the parent that has more time being allowed to move with the child. The burden is on the objecting parent. It's a rebuttal presumption to show that the move is not in the child's best interest. And there's 11 different factors that the court has to consider. But since most often will not have time to mediate a relocation, I won't walk through those 11 factors, but it's worth thinking about. Non-married spouses, two different types of cases: committed intimate relationships. Property division can be done, and if children are involved, paternity action, parenting plan, or child support can be handled. Domestic partnerships, most of them were converted to marriages on June 30th of 2014. And in those cases, we can divide property, divide debt, enter parenting plans, dissolve partnerships, and set child support. There's still a handful of those cases that are allowed under the law. De facto parentage is a statutory, it's not a statutory creature. There's no statute listed. It's a case law creature. Minor guardianships are statutory, and you might see those, but they too have specific time frames and limits and how they have to move through court. So you probably won't. But you might if the primary issue is parenting plan between aunt and mom and dad. So another situation where there could be three. And then a request. People think that what we do in the courtroom is our job, but that is not the only thing that we do. But you see us on the bench interacting with people, making rulings, listening. That's only part of the job. The biggest part of the job is sitting in our chambers and reading. And we spend hours and hours and hours reading. And I would say for every hour that I'm on the bench, I've spent at least an hour in chambers reading the materials to prepare for that hour on the bench. So remember the judicial officers. We hear cases 5 days a week. There is a variety, even at family and juvenile court. And we grab our reading time when we can, because we're generally on the bench from 9:30 to noon and 1:30 to 4:30. So our reading time is pretty limited. We're all scheduled about 3 hours of reading every week, but if you do the math from what I just said, that doesn't work out. So we grab our reading time when we can. We work lunches generally, we come in early, we stay late. We all do different things. Some of us take work home. Some of us refuse to take work home, but we all work really hard and we read a lot. So most of the time, when you're sending people back, if you've sent them back with a parenting plan that they completed on their own or a mediation agreement, you're saving us time and energy and a lot of reading. So thank you for that. And just remember that if we're averaging 20 hours a week on the bench, then there's 20 hours of reading that went behind that. And we're probably doing a lot more than 20 hours a week on the bench. So with that, I thank you for your attention. That is the end of this presentation. I know we went long, but we had some technical difficulties. And I'm happy to answer any other questions, and I will do my best to actually rephrase the questions for those online. And I'm going to stop sharing so that I can see people online if they bother to turn on their videos. I see your names. Yes. Oh, so they can't turn on their videos. Okay. right? That makes sense.
There are a few questions.
Please.
So the first one is, are there definitive legal boundaries about custody, child support, and court session?
Well, hopefully the entire presentation answered that question. And I'm just going to say now, yes.
And yeah, I just.
Well, you sent them to me too. I should look at that.
So number 2 is for parties who do not marry, how are the following: official authority, oversight, intervention, and then parenting plans.
Well, since you sent it to me, I can go one step at a time. Judicial authority over parties is based on the type of case that is filed. So regardless of what your circumstances are, if you file a case, then we have authority as provided under case law or statute, or the Constitution. You don't have to be married to have kids, and people do that, and then people split up and they need parenting plans. So there's a parenting plan cause of action. You can ask for a parenting plan and not a child support order. You can ask for a child support order and not a parenting plan. We tend to want to do those things together because they are both equally important, and the law requires that you provide both physical and emotional support and financial support. So they're equally important aspects of supporting children and raising children. So there's parenting plan causes of actions. There's modifications, which can modify existing parenting plans and existing child support orders. There's a whole process for administrative child support orders where you can go to an administrative law judge and be on the phone and just get child support set in place without any parenting plan. So it really depends on the type of case. The court is reactive. So you file a case and we react to the case that you brought in front of us. We are not proactive. We don't go out there and find everybody that really would benefit from a parenting plan and bring them into court. We serve those who come into our doors. I hope that answers the question.
Are there any issues / topics that should not be included?
Well, yes, and I hope that the training in mediation addresses these things. You don't, for public policy reasons, negotiate child support. There's a formula, there's a statute that governs that in every single state in the nation. And so it's super easy because the statute tells us exactly what to do. 2619, if you ever want to take a look at it, it tells you exactly what to do. When you don't have income information, you make assumptions, and it tells you how to make those assumptions in a priority list. It's easier than parenting plans for the judicial officer. I understand that for people, that can be really painful to have a certain amount coming out of their take home every single day, every single month. But the statute makes it really easy for judicial officers to calculate, and it's not something you should negotiate. I don't think in terms of parenting plan and child support issues, there's anything else that's off the table. But I would say restraining orders, protection orders, there are specific statutes about when those are appropriate. And I don't believe it's appropriate to negotiate those things. And we're not sending people who have reasons for restraints or protection orders to you for mediation if our screening works well. Sometimes it doesn't. We'll send them back.
Under what conditions would the court override the wish?
So I think we kind of covered that in terms of some of the questions that were asked. I gave you some specific examples of where I myself said I can't sign off on that parenting plan, and schedule them for trial instead of finalizing their divorce or parenting plan cause of action. So that really, when it's something super concerning like that, where it just doesn't look like it's going to be logically supportive of a child, where you have 3 months on, 3 months off, or a year on, a year off. It just doesn't make good sense to have a child going back and forth like that with geographical distances. I can't think of any other examples right now, but I'm sure that there are.
And sorry, those were all the pre-submitted questions, and then the questions that we have to ask are how difficult is it a GL assignment?
It is not difficult at all when you come back for a mediation review. So someone came to you, they had mediation, they come back for a mediation review. If there is something to investigate, then we will appoint a guardian ad litem. If they qualify because they are financially unable to pay for themselves, we will appoint a county paid guardian ad litem. The times when I resist appointing a guardian ad litem, even when people are asking, are when there's nothing to investigate. You've got two healthy parents, and what they're thinking about is that system that used to exist where a guardian ad litem would tell them what kind of parenting plan they should have. And that has been determined to be an inappropriate delegation of judicial authority. So we don't do that anymore. So there are times when we won't appoint a guardian ad litem because there's nothing to investigate. You've provided the information. There's no limiting factors there. And there are times when there's one parent who doesn't have any limitations and the other parent has been arrested for criminal behavior, or that's not a difficult case to sort out either. I don't need an investigation. So the two extremes, when they're both really great or when one is great and one is not, those are the circumstances where a judicial officer might say you don't need a guardian ad litem. But if there's something to investigate, then a judicial officer will simply appoint a guardian ad litem. The difficulty comes in if you can afford to pay for a guardian ad litem, it gets expensive quickly because they charge hourly.
And our last question is, parents often have different in different other. Can you speak about it?
So how do we assess appropriate care? There's this idea of a prudent parent. So if you have parents that have been determined to be caring, loving, appropriate parents that don't have any limitations, then who they're choosing to watch their kids are going to be appropriate people to watch their kids because parents love their children. If someone has limitations and has a history of exposing their children to inappropriate people, the court will limit their ability to have the children exposed to those inappropriate people. Anyone who has limiting factors under RCW 26.09.191 and can't have contact with their own children shouldn't be allowed to have contact with your children, right? That's my shorthand way of explaining it to people. And so if there's substance abuse, domestic violence, sexual assault of minors, things that would cause them to be limited in the ability to see their own children, then they shouldn't be exposed to your children. People change, people rehabilitate. I can't be out there determining for every single person. So prudent parent makes good choices is the first place that we start. If they're not a prudent parent and they've made bad choices, then we can put limitations on who they're seeing, if it's shown that that's a problem for children. That makes sense. Yes.
I have a technical question about the relocation,
Yes.
and then I have a question of a recommendation. The relocation question is that I don't know how I was impacted, but one parent, a child relocate to another state, that and up to others.
Yes.
So does that has the authority to take it to that other system of court, or do they stay here?
So another uniform act, the Uniform Child Custody and Jurisdiction Enforcement Act requires that a child live in a state at least 6 months before that state has jurisdiction. So if someone has entered an order here and they've moved to another state and they've lived there for 6 months and they take this order and they register it there and they want to do their modification or enforcement or any action over there, they can if Washington declines, because Washington has original and continuing jurisdiction if one of the parents still lives here. If both parents don't live here, then they can move on in that state and do what they need to do. But if somebody still lives here, we have original and continuing. So the UCC, and that's an oversimplification of a big old statute, but I like to keep it the easy answer. There's law about pretty much everything we do. And so it's not confusing. It's simple and it's straightforward. And when it's confusing, and Washington and Ohio, for example, both have jurisdiction because the kid's been there for 6 months and lives with mom and dad's still here and wants to do a modification here. And Ohio says, we would like to take jurisdiction over here. The UCCJEA requires conversation between the judicial officers with an audience. And then we walk through the statute as to which is the most convenient forum. And if Washington had the original parenting plan, whether that state is going to decline to do further jurisdiction. So there's a whole process.
So if we see that they don't have a work, it's a good question. They other parents here.
They haven't done that work, then it's still Ohio. It's still Washington, because that's where the plan was entered. And no, because it's a creature of statute, and Washington has original and continuing jurisdiction. If they haven't done the work, then it's here.
The other question about we often sometimes one parent and the child, the other parent. They're not supposed to be doing that right now. Period. What are you earlier you said interrupt to what's the relationship? What kind of interruption?
Gosh, I have been on the bench for 17 plus years. I have not been a mediator since 1995, I think was my last mediation. So that particular question, I'm going to turn you back to Ash and everyone else at the DRC, because I know what I do in the courtroom, but I don't know that that is the right thing for the collaborative mediation model. And when I was a mediator, it's not the collaborative mediation model, right? So I was doing shuttle mediation in a whole different arena. So there are some questions that I really shouldn't answer because it's been a minute. 1995 was a long time ago. 29 years. Any other questions? No more from the chat, no more from the room. Then excellent. Thank you so much for your time and for having me back again to talk about these issues. And this time it's recorded, so we can watch it again. And hopefully I didn't put my foot in it, but I do try to stay in my lane. And if I step into the line of the DRC, I would encourage you, whenever there is a policy question or a how do I handle a mediation issue, take it back to them, because that they're the experts in mediation. I'm here just to talk to you about how we as judicial officers think about these things. If you have that in the back of your mind, that might help you get them to a solution, a resolution that could be a real boon to them. And that's why I keep coming back to talk to you. You have one more question? No apologies. It is. We require that all married couples participate in Consider the Children. It's a 4-hour seminar. There are often grants that cover the cost of that, and they charge on a sliding scale fee. So it's not a huge burden. It gives them excellent information about many of the things that I touched on in terms of the brain development, the effect of raised voices in the presence of children, the effect of that conflict on children, talking negatively about the other parent. So many things that we just wouldn't have the time to cover. They cover so well in a 4-hour seminar.
No, I thought I heard
The mandatory Consider the Children class. Yes. Excellent. Excellent. Okay. So for those who couldn't hear, when people come to set up their mediation, they are referred to do Consider the Children. So they should have done the Consider the Children class before they come to you. We do ask them to do it up front, because the sooner they do it, the more likely they will come up with a resolution. But I will order them to do it at trial if they haven't done it yet. If I don't have that certificate, I will order them to do it, and I'll put language in the order that you can't file a contempt motion to enforce this parenting plan until you filed your certificate.
true nature of more questions. So you have
Wait,
time?
I said 7:30, right? So
Yeah,
we're golden.
You do, yeah. So the first one is, will courts typically approve a parenting plan where both parents agree to split residential schedule of multiple? For example, if a parent has 3 kids and they agree that dad having a full-time residential one, mom has 4.
So I have approved parenting plans where they have split children. I do ask extra questions about why it's in the best interest of the children to split the siblings. Sibling relationships can be complicated, but they're also pretty much the most long-term and supportive relationships that you can have. However, sometimes it's necessary to split children because of, that's my phone, sorry, because of the circumstances. So there could be complicating things that require children to be split. when there is no complicating thing that require children to be in separate households, before signing a final order, will ask, how are you going to support sibling visitation and those relationships? But generally, I don't, I come back to the prudent parent rule. People love their children and they're doing what they believe is best for their children. And if I don't have evidence that there's something that's not in the child's best interests, I don't stand in the way of agreements.
Then the second one is put on money sheets, money worksheets not be requested to be revised more.
Child support is reviewable every 2 years, and sorry, I'm just silencing my cell phone. Is reviewable every 2 years and with a substantial change in circumstances. So you can automatically, for no reason, have it reviewed every 2 years. But if there's a substantial change in circumstances, you can have it reviewed sooner. So I've seen child support orders reviewed because somebody lost a job, because somebody was incarcerated. Now there's automatic language because the law changed that automatically changes the transfer payment. So we see less and less of we're incarcerated, so we need a change in the child support order. But it's 2 years for no reason, substantial change of circumstances, so it can happen anytime.
One more. Two, and just it was someone needing to summarize and mediators' rights of parties.
The mediator should not write the parenting plan agreement on the parenting plan forms. However, if the parties come in with parenting plan forms and they want to capture their agreement on the parenting plan forms, they can do that. And my encouragement to you is to talk to the DRC about their lines and rules and what they want you to do. My understanding is that you should write up the settlement agreement and leave that work to parties and their attorneys or the court facilitators. But you have a different answer than that? Okay. Okay.
Or is it? Oh no, you already.
Okay.
About the parent. That is the parent.
So a parenting plan is intended to be a final order, and so it shouldn't ever change, right? There's a finality to that, but there's also an avenue to modify a parenting plan. There is no automatic, we review it every 2 years. There's no automatic when a child is 13, we review it. A modification can happen if there is a substantial change of circumstances, wait for it, in the household of the child or the non-moving party. So not the party that's bringing the modification action. If there's a substantial change of circumstances in the household of the other parent or as to the child, then a modification can begin. There's a preliminary step of coming to the court and establishing whether there's adequate cause, which is a pretty high burden because the statute is written in such a way that parenting plans should be final. And then, even then, the court is required to maintain the final parenting plan unless there's detriment, integration, agreement, or there's been findings of contempt at least 3 times in the last 2 years. So there's a lot of other nuances, things that we can do that are minor adjustments. But for a major change to a parenting plan, I just summarize the statute. So the question was, oftentimes in mediation, parents of young children, 2 and 4, don't know what to do when the child is 15 or 16. And that's fair. And that's appropriate, right? Because children are individuals and they'll have different personalities and different interests, and things may change. Every time I sign a final parenting plan, I encourage parties to let this get dusty. Put it in a drawer and forget about it and live your life. Parent your child, be flexible. When you cannot agree, dust it off and do exactly what's in there. If it's no longer practical, then if there's a substantial change of circumstances as to the other parent or in the life of the child, come back to court and modify it. But really be thinking about past, present, and future performance of parenting functions as I laid it out, so that you can have a parenting plan that keeps them out of court. Court is adversarial by its very nature. No matter how much we try to be more compassionate and appropriate and respectful and gentle, walking through those doors makes you pits you in an adversarial position, and co-parenting should not be adversarial. So if we can keep them out of court, then let's keep them out of court, because co-parenting really is about being flexible and adjusting. So every single time I sign a final parenting plan, I encourage parties to let this get dusty. Don't lose it though, because when you cannot agree, pull it out and follow it letter to letter.
Do layout.
Oh,
Not really. This will be better.
yes, yes.
Okay.
So agreement is one of those 4 times where we can change it, right? Agreement, detriment, contempt in the last 2 years, contempt or interference, and integration. Yeah. Agreement is absolutely one of those 4 times where we can, and again, prudent parents, they know what's best for their children. Okay.
Finally. No more questions.
And thank you all for your time and attention and great questions. You keep me on the ball.
Thank you, and everybody here, please, round of applause. Everybody who's online, also round of applause. Thank you so much for being here.
Oh, look at that.
Oh, yeah, perfect, excellent. I will be, if you take these home with you, great. For people online, I will be, I took a screenshot of all of who attended, and I will be sending those the slide notes after this session. And yeah, thank you again once more.
You are very welcome. Thank you all. It's a pleasure. Okay, I'm going to get out of the way so you can do your thing.